at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. I want to begin by extending my deep appreciation to our extraordinary clerk, Joe Stanton, and his team for setting up this Zoom video conference hearing platform live streaming to YouTube. It has enabled the Appeals Court to continue business as usual. While it's not the full equivalent of an in-court hearing, it is as close as possible during this pandemic crisis. There are a few things that are a little different. You will see that it is not as easy to know when someone is speaking. When we have a question, we interrupt you, and we apologize for that. Would be no rudeness, but please be attentive to the fact our box will light up, and if you would pause for a moment to hear the question and then respond to it, we would appreciate that. There is a timer that will appear in the Zoom box where our seal currently appears. When we begin the argument session, that will count down. It doesn't have the green, yellow, and red lights, but otherwise it does give you the time left on your argument. The rules otherwise are the same as in any argument. 15 minutes per side. If more than one attorney is arguing on either side of the V, we would like to know ahead of time how you'll be dividing your time, and there is no rebuttal. We will have questions for you, and of course, if you address all of the points you need to raise before your time is up, you needn't use all of your time. If you don't reach all of your points before your time is up, you needn't be concerned. You can rest on your brief. With that, I guess the only other thing I will say is that, as always, we have read your briefs. We know your the factual background, the procedural background. We're familiar with the record, and so we will use the argument as an opportunity to elevate the conversation above what you've already told us. And with that, I will call our first case, case number 2019 P1710, the Commonwealth versus Jonathan Pasquarelli.
Sorry, I don't, my video is frozen. Is that just on my end?
Your video's frozen on my end as well.
Everybody's is.
I can hear you. Let's soldier on and hope it restores. And if we get locked up, I'll have Brittany start us in again.
Okay. All right. Thank you, Mr. Chief Justice. May it please the court, Patrick Levin on behalf of Jonathan Pasquarelli. This is a consolidated appeal from Mr. Pasquarelli's conviction of open and gross lewdness and the denial of his motion for a stay of execution of sentence last fall. There's also a new emergency motion for a stay of execution that I filed last Friday and that I understand has been referred directly to the panel. I would like to start on the stay and then move to the merits afterward. Because my position on the stay obviously has changed a bit since I originally filed the memo. In the memo on the appeal from Justice Sachs's denial of the stay, I said that he was only interested in the stay if he's going to win the appeal. I don't think I need to belabor the point that he is, if the panel does agree with me that the conviction should be reduced, that he should be let out as soon as possible. But I do want to now argue that even assuming that the court does not agree with me as to the merits of the appeal, the stay still should be granted until this court's rescript issues to the trial court and he has an opportunity to file a motion to revise or revoke the sentence in front of the sentencing judge.
Why is that? I'm a little lost on that one, because my understanding of the basis for a stay rests on the success on the merits of the appeal.
Your Honor, the stay doesn't require that he succeed on the merits. It only requires that he have an appellate issue that's worthy of presentation to the court, which is the.
I understand that, but once the merits reach the panel, that question sort of merges, doesn't it?
No, I don't think it does. If you look at Commonwealth versus Allen, which is sort of the foundational case in this area, the language that the court uses is that the stay is not to be granted if the appeals were frivolous or brought solely for purpose of delay. The question of whether the appeal is frivolous is a separate question entirely from whether he is going to succeed ultimately in winning the appeal.
Don't we also have to weigh, this is Justice Maldonado, don't we also have to weigh the likelihood of success? And so in that sense, there is some sort of merger, as Justice Green has pointed out.
Yes, but as I say, the likelihood of success prong for purposes of the stay of execution only requires that the issue presented be worthy of presentation to the court. It doesn't
Yes,
require
but that's
an
true
issue.
at the outset of at the entry of the case. It seems to me that by the time it reaches the panel, I don't read Allen to suggest that that if the panel has already undertaken full consideration of the merits and concluded that that there is no merit in the appeal, that we would grant the stay of execution while we prepare the opinion affirming the conviction.
Well, Your Honor, under present circumstances, I want to emphasize the interaction of Rule 31 and Rule 29. Mr. Pasquarelli is not entitled to file a motion to revise or revoke his sentence until the rescript of this court issues to the trial court. So
I'm sorry, why is that? I thought Rule 29 is independent. Revise and revoke is within 60 days. It's not dependent on the appeal.
Your Honor, it's within 60 days after sentencing or after issuance of the rescript affirming the conviction. So there's a new 60-day period after this court's rescript issues in which he's entitled to file a motion to revise or revoke the sentence. And I think that's very important right now, where we have a very unusual situation, obviously, in his conditions of confinement, and he's not allowed to bring that in front of the sentencing judge on the revise or revoke until the appeal is finished.
I understand the interaction on the revise and revoke, and I still have difficulty at an analytical level getting my mind around the suggestion that that if we disagree with you on the merits, that the panel would grant a stay for a conviction that we have determined we are going to affirm.
Well, Your Honor, the fact is that it's within this court's power to grant a stay of execution until his conviction is final, which it is not at this juncture. And
I understand that it's within our authority, but we also need to have an appropriate basis to exercise that authority. And I understand that there is a great deal of concern about risk of COVID infection. But the idea that we would exercise our authority to grant a stay of execution of a sentence for a conviction that we have determined is going to be affirmed is difficult for me to get my mind around.
Well, Your Honor, let me speak briefly to the second prong of the stay analysis, because I do think it informs the court's exercise of discretion in this respect, which is to say that Mr. Pasquarelli has served now 14 months of a 2-year sentence. He's got something like 8 months left when you account for good time. And the question here, assuming an affirmance and assuming that the motion to revise or revoke would not be successful, is whether justice requires him to serve that 8 months now or not until after his conviction is final. And when you look at the purposes of incarceration as a punishment for a crime, I mean, essentially it's fourfold. There's the purpose of retribution. Mr. Pasquarelli was not sentenced to the conditions of confinement that he's now facing. And in fact, if the judge had purported to so sentence him, that would have violated the 8th Amendment, as I think several justices of the SJC recognized in the Foster versus Michi oral argument. The current conditions of the 23.5-hour lockdown per day do raise substantial questions as to the 8th Amendment. In
Mr.
terms of
Levin, if we had agreed with you that the conviction should be reduced to indecent exposure, would he have served the maximum amount of time under that
he
statute?
served, Your Honor, he served more than twice the maximum that he could be sentenced to for indecent exposure. I guess I will turn to the merits at this juncture. Obviously, the argument in the brief is that there's two elements relating to intimidation or fear that the SJC has held are required to be proved in order to raise the conviction of indecent exposure to one for open and gross lewdness. There's a subjective element of shock and alarm, and then there's a separate element that requires the reaction to be objectively reasonable. Now, there's that last element is new. It was imposed by Commonwealth versus McGuire 3 years ago. And there,
Before you get to the substance of McGuire, I'm curious as to why you're citing the dissent in the appeals court. Is that case have any legal effect now that the SJC has overruled the majority in that case?
Your Honor, I've cited the dissent in just a couple places in the brief. Mostly I'm citing to the SJC's opinion of McGuire.
Okay.
But I do think, given that the SJC agreed with the dissenting opinion of McGuire, that it has a certain amount of persuasive value, regardless of whether it binds this court. But to move to the SJC's opinion in McGuire, they did specifically call out this question of whether it's reasonable, objectively reasonable for an experienced police officer who's investigating this crime and voluntarily places themselves in a position to witness it in order to make the arrest, whether it is objectively reasonable for that person to also feel the necessary shock and alarm to make out the open and gross lewdness charge as opposed to indecent exposure.
Well, wouldn't you be saying then that we would need to say, as a matter of law, that an investigating officer could never be shocked and alarmed?
As a matter of law, that it is not reasonable for an investigating officer to be shocked and alarmed by the specific conduct that they're anticipating and consciously investigating.
And you acknowledge that the SJC did not say that, and there is no case previously that has said that.
That's right, Your Honor.
So you're asking us to make that determination as a matter of law.
That's right. I'm asking this court to make the determination as to objective reasonableness.
Yeah.
Well, but let me ask you, because in McGuire, it was a report of somebody that had exposed himself, and the police officer kind of was chasing him through an MBTA station and came upon him, and there were some women that were sitting there that allegedly had seen the exposure. As compared to here, we have a sting operation, right? So this female police officer knew if this was the guy and if he was going to do what he had previously done in that neighborhood, what she was going to see. Does that factual distinction, is that important?
I'm not sure that factual distinction is key here, especially given that the SJC didn't actually analyze this element in McGuire. But I think that the important factor, the important facts are essentially twofold, right? It's that this is a police officer who, as the McGuire cites Commonwealth versus Mulvey, which is a case from this court, noting that, you know, behavior that only affects members of the police force has a substantially different impact as to the public interest than behavior that impacts members of the general public. And that's because the police, it's an inherent part of their job to investigate and to intercede to prevent even serious crimes and very distasteful conduct. And so in terms of the public interest— But you
acknowledge that the officer's testimony that she was in fact shocked and alarmed is entitled for purposes of Lattimore to be given credit.
Yes, I haven't challenged the subjective element in this appeal.
What you're saying is that that as a matter of law, it was objectively unreasonable for her to have that reaction.
In light of the nature of the investigation that she was undertaking, yes. Yep. And the fact that she's voluntarily placing herself in a position where, and in fact, the whole point of the investigation that night was for her to witness this conduct in order to be able to make the arrest.
But this is not like the strip club case that back in the whatever it was, the 70s, that where people were there specifically because they sought out that kind of nudity for entertainment purposes.
No, we're not contending that the behavior at issue here is constitutionally protected. It's just a question of.
Well, no, I'm talking about though the state of the audience member, if you will. The detective is placing herself in the position to view this behavior, but not doing so out of a specific preference or desire to have that experience.
Well, I do think that as to so Revere versus Osella, I think was more of a declaratory judgment type action where they were attempting to enjoin prosecution. But if it had been brought as a criminal action and a police officer had, in order to make out the charge, gone into the club and then subsequently testified that they were shocked and alarmed by what they saw there, I do think that would be the same in terms of objective reasonableness of the reaction as the argument that I'm making here. But let me just
point out that police officers in the course of their work are subjected to any number and range of different shocking and alarming observations. Scenes of violence, for example.
Yes.
The mere fact that that is a part of their job does not inoculate them or immunize them from ordinary human reactions.
No, it doesn't at all. And I specifically disclaim in the brief any argument that police officers are categorically immune from experiencing shock or alarm upon the sight of an open display of public lewdness.
So what then about this? Okay, I'm sorry. So then what?
It's the fact of the conscious anticipation and the voluntary nature of her placement of herself in the position to see the conduct. So if she had been caught off guard by this same conduct, I would have no argument. It's the fact that she's consciously investigating this particular string of nonviolent flashings that renders this. Yes, Justice Maldonado.
Evidence that placing oneself, or some kind of expert evidence that once you place yourself in that position, you can never be shocked and alarmed. Wouldn't you need more than that? I mean, it can, let's say it was a new officer who's at this point, asked, hey, I want you to investigate this. Okay, I mean, it doesn't have to build on experience, what they've seen before, when one takes on that kind of investigation, they have they've already put themselves in a different mindset. And we don't have that here.
Your Honor, I think that type of testimony might go to the subjective element. But what I'm asking for is it's a legal question as to the objective reasonableness as a matter of law, and it's not about the officer's particular experience. It's about the nature of it's the combination, and both of these are necessary to the argument. I think we're going to
have to leave it there. I think we have your point, Mr. Levin. We'll hear from the Commonwealth.
Thank you.
Good morning, Your Honors. May it please the Court, Kathleen Leary on behalf of the Commonwealth. I'm just going to jump right into the merits of the issue first. Here, what is at issue is whether or not the fourth element, which is the manner in which the defendant acts, causes shock and alarm, and whether that is objectively reasonable. And so the SJC in McGuire, and even by the cases that it cites in McGuire, that objective standard is based on a reasonable person standard, not based on the unique qualities of the putative victim. And I would to the fact that this court in Mello already addressed and analyzed the fourth objective element under this reasonable person standard, where it talked about whether the defendant's conduct there, which was dancing around a gasoline station with his buttocks exposed, would cause an ordinary adult to be shocked and alarmed.
But Ms. Here, you have a situation where I think, if I remember correctly, and please correct me if I'm wrong, these two officers spent about 2 hours on Bridge Street waiting for this to happen. She's walking up and down the street. He's walking up and down the street. There had been 5 or 6 reports. She knew what was coming, didn't she?
Yes, Your Honor. There was testimony to the fact that they were looking essentially to catch the defendant in the act as he had become a suspect approximately 4 days earlier. However, I don't think that goes to the objective reasonableness of a reaction of shock and alarm to the defendant's act of stalking and targeting a woman walking by themselves and flashing them and asking them to put his penis and testicles in their mouth. I think that factor goes to the subjective 5th element, and that protects that 5th subjective element is the impact element that protects against the defendant's conduct from being from being a felony to a misdemeanor. And so I think it's not irrelevant, but I think
so if he hadn't said anything, but he had only exposed himself, would your argument be different?
No. I think the act of the circumstances, I think when you're looking at the objective reasonableness of shock and alarm in the attendant circumstances, it's based on the defendant's actions, and the defendant's actions in those circumstances, which include in this case, circling a woman walking by who he doesn't know she's a detective. It's based on his actions of a woman walking up and down the street by herself at night, stopping his car, poking his head around the corner of the street, getting back in his car, circling around her. And then when her back is turned, coming up to her and saying, "Excuse me," she turns around, he exposes his testicles and penis and says, "Can you put this in your mouth?" And I would point to although in Mello, the court did say part of what adds to the objective reasonableness of shock and alarm was the fact that the defendant had sexually assaulted the victim before. I think that all goes to the attendant circumstances of why this is shocking and alarming. That's not unique to the putative victim in that case. It's about the circumstances in which the defendant's acting.
Okay, so you're saying that the defendant is trying to make it that a police officer cannot, in this position, who's doing this investigation, cannot be reasonably or objectively shocked and alarmed. And you're saying that the element of shock and alarm doesn't go towards her position, but more whether those acts are such that a reasonable person would consider themselves to be in shock and alarm. And then when you look at that, then you look at her subjective reaction. Is that what you're saying?
Yes, I think so. It's long-winded, it's very circular. So just, I guess, to make it more concise, so my point is very clear, is you look at the circumstances in which the defendant's acting and whether an ordinary reasonable person under a reasonable person standard would find those acts to be shocking and alarming. And then for the 5th element, you would look at subjectively whether they were in fact shocked and alarmed. And I think there is a case to be made in fodder for cross-examination, an argument that the fact finder should not credit that they're shocked and alarmed in those circumstances. So it's, and I think if you make as a matter of law, I'm sorry?
But then that goes to the fact finder.
Yes.
Right. And you're saying, okay, so would those actions cause a reasonable person to be shocked and alarmed? Once you meet that standard, then you say, was this person actually shocked and alarmed?
Correct, Your Honor.
So how do you distinguish McGuire? That was also a police officer.
So I would distinguish McGuire in the fact that, one, the court didn't reach the objective standard because they found that they didn't meet the subjective standard, so they didn't address it. And I think the footnote in McGuire regarding Piera, noting that this court didn't address whether or not it was objectively reasonable for an experienced police officer to see somebody masturbating was shocking or alarming. I would first note that that is dicta, and it's also contrary to the court's decision later in McGuire discussing the objective reasonableness standard, saying that it's a reasonable person standard, and then citing case law such as Sullivan, which is 469 Mass 621, 2014, discussing what, and that's an annoying and accosting a person of opposite sex, but citing that for an objective reasonableness standard of an ordinary person. So I think McGuire is not necessarily controlling in this for those reasons. If the court has no further questions, I'm happy to rest on my brief.
Do you have anything further to say about the stay?
I would asked this court to deny the stay. One, because I don't think based on the arguments I've made here today, there's a likelihood of success on appeal. And two, because of proposed, I think, security risks if he's let out. However, if the court were to disagree with me and find that there is a likelihood of success on appeal, I think perhaps it's in this court's discretion to allow the stay, but I would urge the court not to.
What do you say to the argument that whether there's a likelihood of success or not, there's 8 months left on a sentence that he would be entitled to revise and revoke once this issued, and given the circumstances of the current incarceration, which could not be predicted at the time that he was sentenced, that there is other grounds to say we don't even have to worry about he has a meritorious appeal, because at least there is a question here, and there may be reasons to revise and revoke, and that alone would allow for a stay, because maybe a judge would in fact allow a stay when there's only 8 months left.
Well, I guess I had trouble
I mean,
following
would
that
revise
argument.
the sentence rather.
Yes, Your Honor. I had trouble following that argument. It was the first time I had heard it. So I'm not sure I'm going to have the most intelligent answer for you. However, I would say I don't think these conditions that the defendant is under meet cruel and unusual under 8th Amendment. And I don't know. I just don't see how a revise and revoke based on that would be successful. That's the best answer I have for you. I'm sorry. I wasn't fully prepared to answer that as it wasn't briefed.
Right. No,
All
I
right.
get it.
I think we have it. Thank you both. Thank you for participating in this virtual hearing, and the case is submitted. We will move now to the next case. Okay,
Okay, we should be back live streaming.
we are back in session. The next case is case number 2019 P814, the Commonwealth versus Jose Alvelo. The rules for this video conference, the procedures are exactly the same as in an in-court argument. 15 minutes to a side, no rebuttal. We are familiar with the arguments that you've made in your briefs. If you have reached the end of your time without having reached the end of your arguments, you can rest on your brief for the remainder. If you reach the end of your arguments before you reach the end of your time, there's no need to consume all of your time. So with that, Mr. Smith.
Good morning. May it please the court, my name is Andrew Smith and I represent Mr. Alvelo. Today I'm asking this court to either overturn Mr. Alvelo's convictions and return him to the trial list at Hampden Superior Court, or to find him not guilty of the charge of A and B with a dangerous weapon causing serious bodily injury. For purposes of oral argument, I'll begin with issue 2, the issue that relates to the use of prior consistent statements by the Commonwealth in an attempt to rehabilitate the complaining witness. I'd like to start. It's a little difficult to disentangle, given the extent to which the witness's testimony varied. But I think the core issue is captured in an exchange in what is marked transcript 1, 7/24/18 at the bottom, starting with Mr. St. John, trial counsel for the defendant. He says along the lines, I'm trying to rehabilitate the witnesses. Oh, I understand the Commonwealth is trying to rehabilitate. The issue, however, the witness was not challenged with these statements as prior consistent statements. So I think this is somewhat expanding the scope of what was being challenged, rather than just saying, okay, well, everything you said today. Later on in that exchange, the Commonwealth responds with, I think is what the core, the core issue involved here, where the district attorney says, so I think this is on, I'm sorry, 186. So I think it certainly falls under prior consistent statements for the Commonwealth to then go over everything that's in that statement that is consistent. To only touch on areas that were addressed by defense counsel, as far as what was missing, that doesn't really allow us to use consistent statements because of those things were in there. Now, the Commonwealth in its brief relies on the case of Seng, S-E-N-G. For some reason, I didn't write down the citation, but referenced in the Commonwealth's brief. And I think it's important to discuss Seng and what it actually stands for. It appears that the Commonwealth is using Seng as an open invitation to use prior consistent statements, whether they were challenged or not challenged in the course of cross-examination. And in fact, what Seng stands for, oh, I apologize, page 35 of the Commonwealth's brief. What in fact Seng stands for is the factual situation in that case was the complaining witness in one context mentions a machete as the weapon used in the assault and battery, and then in another instance doesn't mention the machete, and the defense counsel cross-examines on that issue. And the prior consistent statement is allowed because at another time, she had mentioned the machete as being the weapon of choice in the assault and battery. So it was consistent with trial testimony, and but there was one time when she didn't use it. And at the beginning of this exchange, closer to page 181, 182 of the 724 date, the DA is asking questions related to statements that were both inconsistent in the past, but also there were times when she was consistent in the past. Once we get to this issue that I started the discussion with, where the defense counsel says, "Hey, we're going far afield here to things that weren't challenged on cross-examination," that I think is really where we start straying from what's permissible.
Even assuming that some of these statements, and I know there's a question as to which ones were objected to, which one were not objective. Are we looking at a substantial risk for some? Are we looking at a prejudicial error for others? But even assuming that some of this was not proper impeachment with prior consistent statements, don't you have a problem on the prejudice prong where some of what came in was otherwise corroborated in other means? I mean, she says she was kicked and she's got, broken, serious injuries and a deflated lung. She and has trouble breathing. She says, he was trying to rape her and took off his clothes, and he's arrested. He's found naked coming after her. So there's a lot of so when you look at the evidence, there's a lot of overwhelming evidence that supports her testimony, number one. And then number two, you have the jury acquitting him on 2 serious charges. So in terms of how he was prejudiced, don't you think that that's your argument sort of at that point starts to lose weight?
Well, I think the Commonwealth makes our point perhaps better than I did. The issues where she strays the most from trial testimony play a large part in the charges that are found where he's found not guilty. And again, it's hard to disentangle given the kind of chaos of her testimony, but it does appear that where she's buttressed by prior consistent statements that were not challenged in cross-examination, those appear to be the kind of the basis for what he's found guilty of. So it's.
I'm sorry, I thought they were the basis for what he was found not guilty of, the attempted rape.
No, the ones that are consistent with Sang, he's found not guilty with.
Right.
Walk
me through, as best you can, the clearest illustration of prejudice for the charges on which he was convicted on a prior consistent statement where there was an objection.
The line of questioning relates to right, because the defense counsel says this line of questioning. Again, it's unclear when that line begins.
I think rather than talking about broad characterizations, I think it would be helpful, to me at least, if you could identify a prior consistent statement that should not have been allowed, that and then tie that to a showing of prejudice.
He approached you with a knife and started to scream at you, accusing you of cheating. You said in your, I'm on 185 top to middle. You wrote in your affidavit, he started to grab me, punching me in the face, grabbing me by the hair, threw me to the floor. Is that correct? Yes. You also indicated in your affidavit, that's when he started to choke me almost until I passed out.
Okay, but in terms of the effect of that prior consistent statement on the fact finder's determination of the evidence on the ABDW serious bodily, where's the prejudice? That there was abundant evidence that he attacked her and that she suffered serious bodily injury. And we can talk a little bit. I know you've got a separate argument about whether it satisfies the element of serious bodily, but his identity was not at issue. The fact of an attack was not at issue. Where is the prejudice?
Well, the defense's case was that this was contrivance. So anytime the prior consistent statement is used, it buttresses a trial testimony.
What was contrivance?
That he was the attacker.
The entirety of the attack was contrivance. But his identity as her assailant was independently established by a variety of evidence outside of her testimony.
The only witness who would have seen anything related to her trial testimony was a driver on the street who was never called. He doesn't admit to this. She accuses him of this. But I think, and then no one's challenging that she was attacked and was hurt.
That's where we're confused. That's where I'm confused. And he's not challenging that she was attacked and she was hurt. And he's acquitted of several serious offenses and only convicted of some. I guess we're trying to find out where is that prejudice?
Well, I would say the prejudice is to a significant extent, I think the statements, the prior consistent statements that were not challenged on direct are taken as true.
The fact that she was allowed to testify that she had previously identified him as her assailant created prejudice warranting reversal. That's your argument?
I put it another way. I think there's a possibility, especially with the split verdict, that we have a jury that came away thinking some of this happened and some of this didn't. Some was embellished, some was truthful. That's obvious.
Okay, but so if we place him at the scene as her assailant, we have medical records to establish the extent of her injuries. And they convicted him of assault and battery by means of a dangerous weapon causing serious bodily injury. If we accept as a matter of law that the nature of her injuries established by the medical records were serious, then that it impaired an organ or a bodily function, then I guess I'm having a tough time figuring out where the prejudice is on the admission of the prior consistent statements on the adjudication of his guilt.
Well, buttresses of credibility, but it's why would prior consistent statements be impermissible at all?
No, no one's saying that they are permissible, but there's two prongs of the test, right? It's not, it's one, is there error? And two, did the error prejudice the defendant? Or in some cases here, because some were not objected to, did they create a substantial risk of miscarriage of justice? If you can't meet the prejudice, you certainly can't meet the second prong, right? Of substantial risk, because that's a higher standard. So that's why we're focusing, at least that's why I'm focused my first question on the prejudice. Even assuming there was error, what's the strongest argument on prejudice?
Isn't the prejudice that the use of the prior consistent statements impermissibly, if we accept that, gave the jury the opportunity to split the verdict?
So what you're saying is that rather than say the not guilties or the acquittals are a suggestion of not prejudice, they're a suggestion of prejudice because they show that they were inclined to accept the defense, but for this error. Is that what your argument is?
Your Honor, you said it better than I did. Thank you.
Okay.
If there are no further questions, I would just like to talk very briefly about issue 3. Understanding this is a relatively recent case, the Scott case that we rely on, I will kind of leave the norm of argument and say, I've in fact argued this very issue several times in front of the appeals court panels. And it dawned on me as I was preparing for today's argument that as a defense counsel, much of my response to Scott in these circumstances is something of kind of throwing my hands up in the air.
But you hear, unlike Scott, where, it's a internal liver laceration where there's, there's no explanation that no explanation that there was a function related to the liver that was impaired. What you have here is a lung that's collapsed, and where she immediately says, according to the testimony, I can't breathe, and has trouble breathing then and has trouble breathing afterwards. Why isn't that enough to say it's pretty commonsensical that a lung is where you breathe through and she can't breathe? So there was an impairment.
Well, I'm out of time. I apologize. I would just very quickly say, I think my sense is in the definition in 265, section 13, it's got to be more than she was in trouble for a couple days. Because
they inserted a chest tube. In addition to what Justice Maldonado just described, they inserted a chest tube.
And she was out of the hospital in 3 days.
But it doesn't, from Jean-Pierre that it doesn't have to be permanent.
Permanent disfigurement, and I think the issue is, what does loss and impairment mean?
That was the issue that a panel that I wrote Jean-Pierre 15 years ago. And I still remember it. It's on a short list of things that I remember from that long ago. But it doesn't have to be. It can be temporary. It can be decidedly temporary.
I guess that's the frustration with the case is, does Scott say what it says? Okay, to me, a lacerated kidney sounds no different than a collapsed lung.
In Scott, as I read Scott, the concern was that that there was no indication what effect the laceration had. Here we know from the victim's testimony exactly what effect the collapsed lung had. She couldn't breathe, and that is an essential bodily function that was impaired for some period of time.
And that was for a couple days, but I apologize. Yeah, right. I've gone way over.
All right. Thank you very much, Mr. Smith.
Thank you very much, and have a good day.
Well, stay with us. You'll be able to listen to our exchange with Mr. Lynch. For the Commonwealth?
Oh, am I?
You're unmuted. You're good.
Okay. Good morning. May it please the court. Travis Lynch, Assistant District Attorney for the Commonwealth. I think the panel has made pretty clear that, I mean, the easy answer to the second issue is that there's no prejudice.
So you want to deal with the first answer to that? Because I'm having a little bit of trouble seeing that all of this was proper prior consistent statements.
Well, I mean, as to, I did point to the Hoffer case, and it seems as though under Hoffer, it seems as though under Hoffer you can do this, even though it seems as though the general rule is that prior inconsistent statements are not admissible. And in Hoffer, the witness had multiple prior statements and the defense seemed to select some of the inconsistencies. And then the prosecutor was allowed to examine in some detail the circumstances. But
that's not a categorical free pass. I mean, it seems to me that that you would have to make a showing that that these prior consistent statements in context were necessary. It seems to me to be a close cousin to the doctrine of verbal completeness.
Sure, but
these statements were, yeah, they were part of her overall statement, but they were not particularly related to the grounds on which the defense sought to impeach the victim by inconsistent statements.
In fact, I think the prosecutor seemed to acknowledge that in his closing argument. Doesn't he say in closing that, of course, yes, she's telling multiple stories on the same day. There are discrepancies, but they don't go to the act of the assault, only to the means and manner or something to that effect. So he's almost acknowledged that these discrepancies don't really go to the heart, to a recent fabrication at all, and to the defense's reason for bringing in the inconsistencies.
yes, but
Okay.
I understand the court's point. But again, it is a two-pronged test. The defendant has to show some prejudice here. And as I stated in the brief,
Mr. Lynch, are you conceding error?
I'm not conceding error. I'm just saying that I would just say that this case is sort of like Hoffer. And so, but I understand.
So even if error, there's no prejudice.
Correct. In light of the acquittals, the fact that the objection was to a question. The prosecutor asked if Baez had said in her affidavit that the defendant choked her to the point of unconsciousness. Here's where that's at trial transcript day 185. That's where the prior inconsistent statement or prior consistent statement objection that arguably preserves this claim is made. Then there's the sidebar. That question was never actually answered. So the prosecutor then asks two more questions after that, which arguably are preserved, but assuming that they're preserved, we're talking about two questions here. And I think given the fact that the injuries are corroborated by the medical records and the photographs, there was really not a contest that she was injured. So we're talking about two questions here. And given the acquittals and everything else that happened at trial, don't think that there's a successful argument for prejudice here.
What do you say to the defendant's argument that the acquittals actually show that the jury was inclined to accept the defense, but for these extra statements that that buttressed the ones that he was not acquitted on?
That seems to be against most of the case law, where the court seems to posit that an acquittal indicates that the jury were carefully considering all the evidence.
I always find it pretty hazardous business to speculate on what goes on in that jury room.
Right. We don't want to look into the black box. I mean, who knows? But I don't think that, it seems as though normally this court and the SJC say that the acquittals indicate that there isn't prejudice. So as to, unless there's anything more about issue 2. On the third issue about sufficiency of the evidence, I think the panel has said it pretty well already, but it doesn't require expert testimony to make the connection between the testimony and the medical records that showed that her lung collapsed and the victim's testimony that after she was kicked in the side that she had difficulty breathing. So
you're saying that it's in the jury's common sense that breathing and lung capacity, like that's equate. You don't need anything to tell you that you need your lungs or a failure of the lungs or damage to the lungs equals breathing damage.
Right. I mean, and whether you frame it as, the statute seems to say organ or bodily function. So whether you say, I mean, the lungs aren't working, so the lungs functions are impaired, or your overall function of breathing is impaired. However you want to frame it. I mean, also, she didn't have difficulty breathing before she was kicked in the side. So as a timing issue, you can draw the inference that the injury that the defendant inflicted on her by kicking her caused her to have that difficulty. So,
and does the 3-day hospitalization, is that part of the calculus, that it was only 3 days?
No, because it's not a disfigurement case, so it doesn't have to be permanent. In Scott, one of the things in Scott was that the victim didn't actually receive invasive treatment and was in the hospital for a short time. Here, there is invasive treatment. I don't think that the duration of time that she was in the hospital takes away from the fact that she had a needle inserted into her chest.
And jurors can figure out for themselves what the insertion of a chest tube means?
I mean, that seems pretty invasive. I think that's a pretty common sense inference. But also when you combine it with the fact that she said that she had difficulty breathing. So unless the panel has any additional questions.
Seeing none.
Thank you.
I think the case is submitted, and we will take a brief recess before resuming with the next case on the list.
Very good.
All right. The next case on our list for argument is case number 2019 P1025, the Commercial Wharf East Condominium Association versus the Massachusetts Department of Environmental Protection. Each side has 15 minutes to argue. My understanding is that the appellees will be splitting their time, 7.5 minutes each between two attorneys. There is no rebuttal. The one thing I will say about this video conference platform, occasionally we can experience some technical difficulties. If the screen freezes, that's fine, keep going. But if you lose the ability to hear, please let us know and we will suspend and resume. We've had that happen only infrequently, but if it does happen, we don't want that to impair the experience. With that, Mr. Schofield, you may begin for the department as appellant, rather.
Thank you, Your Honor, and may it please the court. This case in its present posture concerns only how a department form was completed nearly 9 years ago. But make no mistake, the answer to the procedural questions before the court carries significant consequences for how the department may license condominiums and protect the public's rights in tidelands. For at least two reasons, this court should vacate the Superior Court's remand order and judgment. First, the Superior Court erred in its conclusion that the department's regulations and its form required the condominium unit owners to be named as the quote property owners on the department's form request for a determination of applicability.
I'm sorry, was the order that they be named or was the order that they all be notified?
The good question, Your Honor. The order is that they be named in the department's form, but the basis for that finding was the department's notice regulations. So there was a fundamental disconnect in the judge's order between his finding and the regulations on which he relied. The regulations on which he relied are found in at 310 CMR section 9.02, which then requires that's the regulation that concerns a request for a determination of applicability, which is a jurisdictional determination. That provision, subsection 2, then directs the applicant to provide notices to specified parties.
And those specified parties include whom?
They include landowners, easement holders, and abutters. Sort of the normal group of individuals and entities to whom you would expect notice to be brought.
And what is the nature of the interest held by the unit owners?
The interest held, I'm sorry, in their units or in the common areas?
The interest in the property that is at issue in this in the department's action.
So that the unit owners own their units. The request for determination of applicability concerned whether the condominium building and its common areas required a license under the Waterways Act.
I thought that the nature of this entire proceeding was an inquiry into the use of the individual units.
Yes,
triggered by a change over the years from commercial to residential use.
Yes and no, Your Honor. The request for a determination of applicability, which is consistent with the way the Act is structured, concerned whether the building structure, which is what the Act focuses on, required a new license. The trigger for the need for a new license related to whether uses in the building, and in particular units in the building, were converted, whether there was a change in use.
Okay, but even if we take just the building itself, the building consists of a variety of different property interests, right?
To be sure, Your Honor, including the public's.
I understand that. Includes the interest of the public in the Chapter 191 tidelands. It includes the interests of the unit owners in their percentage interests in the common areas, and it includes the interests of the unit owners in their respective units as well. The units are part of the building, are they not?
Yes, Your Honor.
So the distinction that I hear you trying to draw between the building and the units is one that I'm having difficulty understanding.
Well, I think that, and this is a significant point, the distinction is in how the licensing system works. The effect of the judge's order was that the department would need to license individual condominium units. That is the clear import of his order, and that's how the appellees, the unit owner, interveners, and the association are reading.
But setting aside for a moment the specific contours of the judge's order, if we go back to the regulation and identify the parties who are entitled to notice of the proceeding, it includes the interests not only of the owner of the fee, but also easement owners outside the condominium context. The condominium statute is a funny creature. It has not been substantially modified since it was initially adopted in the early 70s, despite a wealth of adverse commentary. But it creates hybrid interests for both the association of unit owners and for the individual unit owners themselves. I have difficulty understanding how it is that the unit owners are not within the class of interest holders identified in the regulation entitled to notice.
Yeah, and we don't disagree with that that point, Your Honor. We're not saying that the so let me address that in two ways. The department has a long-standing policy in regard to condominiums, and it works in, I think it's worked well in most cases, which is when a condominium building is implicated in some type of permitting proceeding, it provides notice to the condominium association on the assumption that the association is the organization of all unit owners and is in the position to make the decisions about the permitting issue at hand. Now, I think this case is a little bit different than some of the cases that the department has handled in the past. So in this case, the department did in fact provide notice to the unit owners on multiple occasions. Four in particular, Your Honor. First, on September 13th, 2013, I can provide the court with the record sites. It's volume 2, page 108 to starting on page 108 to 120. November 8th, 2013, they were provided notice again. That is found in the record at volume 1, pages 209 to 212. Third, on November 4th, 2014, the unit owners were provided notice again, and that's found in the record at volume 2, page 149. And then a fourth time on December 22nd, 2014, the unit owners were again provided notice. Now, in each of the last—
all the unit owners, or
all of the unit owners? Yes. There was a question initially about whether all of the unit owners received the mailing, because the mailing was based on the Boston tax assessor's records, and apparently some of those, for whatever reason, that varied slightly from the address list that the association had, which the association, after a request from the presiding officer overseeing the adjudicatory proceeding, produced to the department so they could mail that last notice on December 22nd, 2014.
Okay, but setting aside the question of the notice, we then have an adjudicatory proceeding before the department, and eventually the issuance of a Chapter 91 license, right?
Could I interrupt, Your Honor?
Please.
That's not an accurate characterization of the proceeding. The proceeding only concerned whether the act applies and whether a license is required. That the proceeding did not concern how the regulations would apply in a licensing proceeding, because it was not itself a licensing proceeding. That's something that will happen in the future.
The distinction is well taken. I understand that. But my question is, you are drawing a distinction between notice and status as a party, and suggesting that only the association is the proper party, if I understand it, right? That's accurate, Your Honor. And I'm having difficulty understanding why that is in light of the nature of the interest held by the unit owners. Because it flows directly from the act itself and its regulations, which focus the department's licensing authority on regulating and licensing structures. And indeed, the department's regulations at 310 CMR section 9.02 define the term structure as building. There's nothing in the court, neither the court nor the association nor the unit owners point to anything that suggests that the department should essentially segment a building into by its internal spaces or view a structure based on unit ownership. That's just not the way the act works. I still have a hard time. I go back to a comment that I made earlier to recognize that the units are part of the building. I think, when I hear in your brief your concern about the parade of horribles for needing to license individual unit owners for new condominiums, I'm not sure I follow that, because in the ordinary course, when a building is, when a condominium is initially created, all of the units are held in common by the condominium developer declarant. It's only in a situation like this where there is a modification or a determination of applicability after the building has been segmented and interest in it. Suppose it was a two-family structure side by side. In that instance, you would, of course, give notice and join the interests of both parties joined by that common party wall. I don't see why the condominium situation is any different.
I just want to be clear, there's no question about notice in this case. The unit owners received notice. Any initial deficiency in the notice that was provided at the outset of the proceeding was harmless, and two separate Superior Court judges so found that the notices were adequate. That's at volume 1, page 232 of the record. That was Judge Kazanjian. And then Judge Raschuti made the same finding, and that's at addendum page 85 of our brief. So notice is just not the issue, Your Honor.
I understand, but the entire licensing regime applies not only to the association but to the individual units within the building.
I would disagree with that characterization strongly, Your Honor.
Explain to me why.
There's no question that the unit owners have an interest in the proceeding, and that they will certainly have an interest in a licensing proceeding. But the fact that they may have an interest in it is very different from saying that the Act's licensing structure or design is focused on the units.
Go back with me for a moment to my example of a side-by-side duplex, two-family townhouse. Okay, who is a party to that proceeding?
Well, it depends on how that was formed, Your Honor. If there was a small association that was formed to manage the interest between the two adjoining buildings, then that would be the entity that would hold the license.
Then I'm talking about a duplex side by side, individual ownership of each of those two side by side buildings, joined by a common party wall.
I think that that's hypothetical. I'm not aware of that ever arising before, but I believe that the answer would be in that case that the structure would be owned by two entities, two individuals, and that both of those individuals would be the licensee. But that's what I would expect.
Now let's change that hypothetical, and instead of being side by side, let's make them up and down.
Up and down vertically?
Yes, first floor is owned by one owner, second floor is owned by a different owner. And let's say that it's not formed as a condominium. Let's say that they decided to get creative despite the availability of the condominium statute and set up a cross easement arrangement to facilitate their separate ownership of their interests in the respective floors.
I think the answer would be the same, Your Honor, but it's not the same answer for a condominium building.
And you say that why?
I say that why because the condominium association has a organization that's established to manage the interests of the unit owners.
But there's a great deal of case law out there that talks about when the organization is the exclusive entity to conduct litigation on behalf of the unit owners, and when the unit owners instead have the authority and in fact the prerogative to litigate on matters affecting their own units.
Well, I think those are different issues, Your Honor, because here the association isn't being sued and isn't bringing a claim against anyone. This case again goes back to a purely jurisdictional determination of whether a license is required. And a license, if it's required, is required for the entire condominium building. And in order for the department to be able to implement and compensate the public for the private interference in the public's use with the tidelands, the only entity that could feasibly implement and comply with such obligations is the condominium association. I would direct Your Honor to the condominium, excuse me, Your Honor, let me make sure I get this right.
It's all right. Don't worry about the time. I used up a lot of your time, and I'll give you a chance to finish your argument.
Yes, Your Honor. I just want to say that I would direct the court's attention to the Union Wharf Condominium Trust, license, which is in the record at volume 7, page 222. That exemplifies the department's licensing of condominiums and the way they have done it in the past and the way they would do it in the future. It also highlights why a license proceeding or a license could not be issued to individual unit owners. There's just no possible way for them to be able to implement or for the department to be able to mitigate the harm to the public interest by doing things like requiring the development of public parks and public walkways. No individual unit owner has that ability.
How does that translate into the circumstances of this particular license where what's at issue is the use of the individual units? Isn't it the unit owners who have the primary means of either complying or violating the regulation of the use of the units?
Well, again, Your Honor, this isn't about liability. It's not about compliance. This isn't an enforcement action. And the question about how the licensing regulations would apply in the future to, for example, the ground floor units is irrelevant to this particular case for 3 reasons. First, as I just indicated, how the regulation might apply in a future licensing proceeding is not before the court. It wasn't before the department. It won't be before the department until an application for a license is submitted. And the presiding officer made a specific finding to that effect, that volume 2, page 121 of the record. Second, the application of the licensing requirements is itself a complicated and multifaceted process, and difficult issues get worked out all of the time in that process along the way. There would be wrong to base a decision today based on speculation about how the licensing regulations and the issues might get worked out in the future.
Councilor, can I interrupt? You said this is an enforcement issue. So it seems to me that the
No, Your Honor, this is not an enforcement issue.
Oh, not an
sorry if I misspoke. This is purely a jurisdictional question of whether the Waterways Act and its licensing scheme applies to the structure and whether a license is needed. How the regulations would be applied in a future licensing proceeding, if a license is at the end of the day required, is a question not before what wasn't before the department and is not before the court.
All right.
If it cannot be licensed, aren't the unit owners then affected by it?
If it cannot be licensed. Well, I don't think we don't know the answer to that question today, Your Honor, and that was the point I was just trying to make, that how the licensing regulations would apply is a question that's hasn't been addressed or resolved and briefed and addressed by anybody. All we have now is
but I guess that becomes a question. When that becomes an issue, aren't the unit owners, individual unit owners' rights implicated?
Their interest would be certainly every unit owner in the building's interest would be implicated by a requirement that the condominium association obtain a license, because that licensing process is going to require certain changes, especially to the areas outside of the building in the terms, and I don't know, can't say today, I'm not the licensing
right,
expert.
no, but if it's going to be implicated, I guess that's the big issue. Why shouldn't they be parties to this?
Well, nobody's saying that they couldn't have been parties to this matter. The problem, and this is again a misunderstanding that the judge had, was that he believed that naming the unit owners in the form made them parties, and that is just absolutely wrong. The only way to become a party to a proceeding is to file a notice of claim from the initial decision of the department's program in this case, or separately, once the notice of claim has been filed, as it was in this case by the condominium association, to intervene in the proceeding. And the unit owners were invited and given the opportunity on multiple opportunities to intervene and become parties in the proceeding. Some of them did become parties to the proceeding as interveners. Most of the other ones decided not to. But it wasn't that they didn't participate, Your Honor. I think is also a very important fact that was overlooked by the judge. 65 unit owners, 65 out of 90, submitted affidavits in the adjudicatory proceeding, asserting their factual basis, and presumably they used those to assert their interest regarding the proceeding. And any notion that they were somehow not aware of what was going on is belied by those affidavits, because they speak to the unit owners attested to the fact related to the use of their units.
I think we're gonna have to, we've gone substantially over time, Mr. Schofield. I think we'll have to leave it there. Thank you very much.
Thank you, Your Honor.
Okay, Mr. Allen, you're going to go first, I gather, since you're unmuted.
Correct.
Okay, let's wait for the clerk to get the timer going. 7.5 minutes. Thank you.
Members of the panel, good morning. My name is John Allen, and I represent the Appellee Commercial Wharf East Condominium Association. We're here today because DEP refused to follow its own regulations, which require a process that conforms with fundamental principles of property ownership and condominium law. In resolving the question on appeal, we aren't operating with a blank slate. We know the correct procedure required in this case from DEP's own previous regulatory actions in 2003 and 2004 that address the very same underlying allegation at issue in this case. In 2003, DEP instituted 2 Chapter 91 enforcement actions alleging changes in use from private office to residential of certain units in the condominium. Those enforcement actions are located at volume 7, pages 130 and 137 of the record. The enforcement actions were not directed to the association as a whole, but against the specific unit owners alleged to have converted their units because they owned those units. Against the unit owners, DEP alleged specific violations of Chapter 91 and its waterways regulations, and they ordered those specific unit owners to either revert the use or apply for a Chapter 91 license. Eventually, in resolving the enforcement actions, DEP did authorize the unit owners directly by issuing the 2004 minor modification pursuant to 310 CMR 9.223, which approved the units to be converted to residential use and then sold as such. In the minor modification, DEP expressly recognized that the changes were merely a change in the type of facility of private tenancy, an insignificant deviation from the existing uses. In addressing the changes of use back then at the time, DEP correctly harmonized its regulatory role under Chapter 91 with condominium law and the individual private property rights of unit owners established by Chapter 183A, Sections 3 and 4. DEP knows the correct procedure, but they've refused to follow it in this case. Basic legal principles of condominium ownership require a distinction here between the common areas, which are managed by the association, and the exclusive ownership, use, and possession of units within the condominium by individual unit owners. But beyond showing that the affected unit owners should have been named directly as required by the regulations and DEP's prior regulatory actions, the actions in 2003 also demonstrate the need to properly perform what the Superior Court termed DEP's vital role as fact finder. DEP's failure to name the directed unit owners resulted in a failure to establish the essential and fundamental facts of this proceeding so that the Superior Court could eventually perform its judicial review function. Because the landowners were not named in the RDA, as required by DEP's regs, the 36 units alleged to have changed use have never been identified. DEP still to this day refuses to provide that basic information. And without knowing which units are at issue, no one can fully evaluate the claims or determine whether they are any different than the claims that DEP addressed in 2003 and 2004 and approved
Well,
through
I guess-
the modification.
Does it matter, is it a matter of which units have changed, or it's a matter of a percentage of units or a number of units? The percentage is no longer in the equation, in which case it's not about any individual unit, correct?
No, Your Honor, it is about individual units, because here we have a claim of 36, but without knowing which units are the 36 can't be disputed. There was an allegation in the enforcement actions back at the time that approved the units that 36 were at issue then. So they are the same units that DEP approved then as now. No one can
That's what I'm not understanding. If you have, let's say, I mean, what do you have, 90, is it 96 units here, 93?
over 90.
Okay, so over 90. And the original licensee was 60 something of those could be one way, or 57 could be one way, and 36 could be something else. I guess I'm not understanding that it wasn't that the licensure was done to individual units, it was done as a group, in which case it's not so much that any individual unit has changed, but that somehow that composition has changed. Isn't that the issue?
The facts of this condominium were that it was created in 1978 before the grandfathering of 1984. And so as of 1984, the condominium had a grandfathered license. And the allegation here is that specific units changed in their use since that time. So the question, and it was not a substantial change that the department actually found, they merely found a change in use. And they claimed that one unit could affect the whole building. But that
So
can't.
when it was grandfathered in, let me ask, when it was grandfathered in, was it grandfathered in that these certain units can be residential and these certain 30-something units can be, and particular units can be commercial? Or was it grandfathered in as you have 90-something units and 60-some of them can be, or 50-something that can be residential, and 30-something of them can be commercial, without demarcation as to which particular units were residential and which ones were commercial?
So the master deed specifically provided, as of 1978, that the units on the first and second floors, plus 2 units on the third floor, could be used either for residential or commercial use. So the uses of those units on the first and second floors were interchangeably residential or commercial. The other units were set as residential use. So there is specific identification for purposes of the units within the master deed. And that is the key here, because without knowing the units, we can't know which ones have this interchangeable use or not. And we can't tell whether units have been approved previously or they haven't been. That's part of the problem here. I just want to conclude with one brief point, if I could. And this really addresses more the RDA proceeding itself. DEP on appeal they have phrased the question as the Superior Court erred because naming the unit owners won't make them parties to the adjudicatory proceeding. But that ignores the important RDA stage of the proceeding, which occurs before you get to the adjudicatory appeal. And the RDA stage is where DEP gathers facts. And if the unit owners had specifically been named, they would have been able to appear, submit comments, submit facts. They also wouldn't have had the burden of proof at that stage of the proceeding, which flipped once an appeal started. So it isn't just a harmless error here, because you ignore, by saying it's only about the appeal process, you ignore the important RDA stage and the Superior Court's decision.
I think we get the point. Thank you, Mr. Allen.
Thank you.
Good morning, and may it please the court. My name is Sarah Toronto Flores, and I'm appearing on behalf of the appellee intervener homeowners. These homeowners all own units on the ground floor of the Quika building. They are all residential private units, and they benefit from both the grandfathering that Attorney Allen just referenced in the 1978 master deed, which allowed ground floor units to be residential, as well as they benefit, each of my clients, from the 2004 minor modification, which authorized those residential units on the first floor. This is particularly significant in this case because the regulations, the licensing regulations set forth at 310 9.513B prohibit facilities of private tenancy, such as residences, on the ground floor of structures located on filled tidelands within 100 feet of the shoreline. Only public facilities of public accommodation are permitted on such tidelands pursuant to that regulation. That's a mandatory regulation. The term shall is included. The DEP has no discretion in its application of those license regulations and that provision in particular. Thus, if the DEP's jurisdictional determination that licensure is required in this case is upheld by the court, these units on the ground floor necessarily must be converted to facilities of public accommodation. The failure at the RDA stage to name the unit owners as owners in the proceeding, as required in the RDA regulations set forth at 9.06 and 9.13 of the regulations, led directly to the procedural and evidentiary issues that arose in the adjudicatory proceeding in 2016. As an evidentiary matter, the jurisdictional determination of whether licensure requires necessarily involves an examination of whether or not any of these units are exempt. We talked about the grandfathering. At section 9.053B, you are exempt from licensure if you are a use in an existing structure on lawfully filled private tidelines, which we are, provided there has been no unauthorized change of use after January 1st, 1984. So the examination at the RDA level and on appeal at the adjudicatory hearing must necessarily have involved an examination of which units were alleged to have changed use, when that change occurred, pre or post 84, how they changed, and whether or not they were previously authorized. Without therefore naming the units and identifying which ones were alleged to have changed use, there was a cascading effect relative to the lack of evidence that the DEP used to examine this issue. All it relied upon was the totem pole hearsay allegations contained in the RDA application that were duplicated during the adjudicatory hearing. It is important to note that on summary decision in an adjudicatory process, the regulations at 310 CMR 1.0111F don't allow hearsay. Only evidence on summary decision that is admissible in a court can be relied upon to make summary decision. In this instance, both at the RDA level and in the adjudicatory proceeding, all the judge heard was the allegations, unsubstantiated by any documents, none of the city records were appended, that 36 units had changed use. This resulted in the error that the court is trying to correct by naming the unit owners.
What relevance do the affidavits that the unit owners filed, what relevance are those affidavits in connection with your argument?
I think that they underscore the fact that in each of those affidavits, they complain, the affiants, who are the unit owners, complain that they don't know what units are alleged to have changed use. And as such, they can't provide and adequately defend the allegations against them. 30A section 11, which governs the conduct of these adjudicatory proceedings, provides that the notice of the hearing be sufficient to afford the parties reasonable opportunity to present and prepare the evidence and argument needed to address those issues that are raised.
So is there any distinction between the unit owners that actually intervened and those that filed affidavits and did not intervene?
I think that in this case, all of them were obstructed by virtue or hindered, I should say, by virtue of the fact they didn't know which units were alleged to have changed use. So they couldn't provide the documentation needed to discover the why, the where, the when, the which, and the whether that I just referenced. The Higgins versus Board of Licensing Commissioner that's cited in my brief speaks that naming them, notifying them of the proceeding is not merely just a procedural issue, it's a substantive right in an adjudicatory proceeding, and due regard must be given not only in those notices to the nature of the proceeding, but the character of the rights affected. And when you compare the 4 notices that went out to the notices and the unilateral administrative orders that went out back in 2003 when this issue was first examined, there's vast differences. The 4 notices we got don't identify the unit owners, don't state in them that the result would be ground floor units are prohibited or residential units are prohibited on the ground floor. And they identify QICA as the entity responsible for the licensing. Look at the UAOs in volume 2 of the administrative record, pages 165 and 176, and you'll see they specifically state in there the units, they identify them by number, and they also specifically reference the 9.513B statute, that a regulation that prohibits facilities of private tenancy on the ground floor. And they state that the developer, the owner of those units who they were issued to, has 2 options. 1, revert to the prior use, or 2, propose a licensed use that comports with the facility of public accommodation uses. So no private residences. Very, very clear in all of the communications that went out back then. And in these notices, very, very vague, don't identify the units and don't identify the consequences. In addition to that, I think that the department's reasoning that QICA is the proper entity reflects the disconnection that Justice Green highlighted in terms of the distinction between what property interests the unit owners have and what property interests QICA have in the building. QICA cannot compel enforcement of an order for the building to be licensed and for those ground floor units to be converted unless the unit owners authorize them to do so. So as such, the unit owners are the parties in interest, and they should have been named in this proceeding. Due to those evidentiary and procedural errors, we ask you to uphold the court's decision.
This is case. We are back on with case number 2019 P994, Jennifer A. Brodbeck versus the Massachusetts Department of Correction. Each side has 15 minutes to argue, and there is no rebuttal. We are familiar with the arguments that you've made in your brief, as well as the procedural and factual background as you've laid it out in the record. For the appellant, you may proceed.
Good morning, Chief Justice Green. Good morning, Justices Maldonado and Blake. May it please the court. My name is Emil Cavalla. With me is Attorney Paul Nevins. We represent Jennifer Brodbeck, the appellant in this matter. Your Honors, Massachusetts does not have sovereign immunity for ADA claims and Chapter 151B claims brought in the state Superior Court. Because Massachusetts, by legislative act, Chapter 151B, waived its sovereign immunity as the state disability discrimination claims by its employees, the state may not selectively cloak itself in sovereign immunity as to federal disability discrimination claims by its employees. To do so would discriminate against federally based rights, which the Supreme Court has said that to do that is in violation of the Supremacy Clause of the United States Constitution.
Counsel, do you have a case for that proposition?
I do, Your Honor. So at the outset, the Commonwealth has waived sovereign immunity for 151B claims in state court. The case for that is Lopes versus Commonwealth. It was quoted in our brief. The SJC said that by its own statutory language, 151B divests the Commonwealth of sovereign immunity for state claims.
I don't think that the Commonwealth is claiming sovereign immunity for the 151B claims, but they, I think what I would be interested in hearing is the authority for your suggestion that claims under the ADA are waived by sovereign immunity.
Yes, Your Honor. So the Supreme Court of the United States in Howlett versus Rose, the site for that is 496 US 356. It's a 1990 claim. In Howlett versus Rose, the US Supreme Court stated that a state subdivision was not entitled to sovereign immunity as to claims based on federal law, where the state has waived sovereign immunity as the state law claims against the same state actors based on the same conduct. 9 years later, the Supreme Court reaffirmed that rule in Alden versus Maine. Alden versus Maine, the site is 527 US 706. It's a 1999 claim. In Alden versus Maine, a probation officer had sued the probation department for violations of the FLSA, federal wage and hour law. And the Supreme Court said because Maine does not have a state equivalent to the FLSA, and it didn't at the time, it has not waived sovereign immunity under state law, and therefore it does enjoy sovereign immunity under federal law.
Were either of these cases cited in your brief?
They were not, Your Honor. The argument was made. It's the very same argument that when the state has divested itself of sovereign immunity under state law, it cannot claim sovereign immunity under federal law.
Where is it that you suggest Massachusetts has waived sovereign immunity for the for EDA?
For the ADA, so it's because of the holding. So on Howlett versus Rose and Alden versus Maine, both U.S. Supreme Court cases, they both hold that when a state has enacted an equivalent state statute for which they have waived sovereign immunity, they cannot then claim sovereign immunity for the federal equivalent claim.
I understand that. What I'm asking you for is what is the state statute, the state law that Massachusetts has waived sovereign immunity for that you contend is the equivalent?
Chapter 151B. Chapter 151B prohibits the discrimination based on handicap. We call it handicap in the Commonwealth. The ADA calls it disability, but they're the same exact thing. Disability and handicap discrimination are the same thing. Lopes versus Commonwealth holds that. And the Lopes court cites numerous decisions, and they say that this, by its own terms, 151B subjects the state to disability discrimination claims. Also, Your Honor, the DOC relies on Shedlock versus DOC, which is an SJC case. At best, Shedlock left this question open. They did not decide it. In reality, what Shedlock held was that because the claim brought by the plaintiff, Shedlock in that case, was based on Title V of the ADA retaliation, Massachusetts had not enacted an equivalent to Title V retaliation, either under Article 114 of the Declaration of Rights or under Chapter 93, Section 103. Therefore, the Commonwealth was immune in that case. But Shedlock left it open. In Note 14, the SJC specifically said that they're not deciding whether or not other ADA claims would be prevented because of sovereign immunity. But what they did hold is that because there was no state equivalent, either under the state constitution, the Declaration of Rights, Article 114, or by statute, therefore, the Commonwealth enjoyed sovereign immunity. And the inverse is true in this case, whereby the Commonwealth has waived equivalent state sovereign immunity for equivalent claims and for discrimination, and therefore it would violate the supremacy clause of the United States Constitution based on Howlett versus Rose and Alden versus Maine to keep out federal claims from state court.
Setting aside the question of whether the waiver of immunity for 151B necessarily sweeps in claims under the ADA, what about the statute of limitations?
So, Your Honor, there are two. I just want to clarify something. The statute of limitations for the ADA had not expired as a matter of law when Ms. Brodbeck filed in the Superior Court. The statute of limitations under the ADA is 90 days after receipt of a right to sue letter from the EEOC. The state is different. The state is 3 years.
Because doesn't it say unless contrary to state law?
No, Your Honor, there is a plethora of case law that I cited in my opposition brief in the Superior Court that fleshes out this exact issue. For federal claims, for federal discrimination claims, a plaintiff has 90 days from the issuance of the right to sue letter. That could be less than 3 years, that could be more than 3 years, but the law was changed specifically to prevent what is happening in Ms. Brodbeck's case for the state claims. People the legislature, the Congress didn't want people to forego a right simply because the case sat at the agency level for too long. So they gave people 90 days to file the federal claims in court after the right to sue letter was issued. And like I said, that was briefed extensively in the lower court. I don't think matter of fact, the DOC, I don't think contends that the ADA was prohibited from being brought because of statute of limitations.
Let's talk about statute of limitations as to 151B.
Yes, Your Honor. Statute of limitations under 151B must be told, and the DOC must be, the executive really must be prohibited from asserting the statute.
What is the event that you suggest causes the tolling period to begin?
The event is the appointment of Commissioner Quinones by the chief executive in the Commonwealth.
When did that happen?
That happened 1 week before the case was scheduled to go for a public hearing at the MCAD.
What was the date?
September 27th, 2017.
Yes, September 2017. Thank you, Justice.
Okay, and when did the 3-year period run?
That a couple of years before that, Your Honor. It was well over.
So how can you're not asking for tolling, you're asking for resurrection?
I am asking for tolling because
that's if the tolling is based on something that didn't occur until after the statute of limitations period had run, you're not asking for tolling.
I assume it may be called resurrection, Your Honor, but the principle is the same, that it was the.
I don't understand how, because the claim, the rights are already lost with the running of the limitations period. Subsequent events are irrelevant to any reinstatement of the claims, aren't they?
Well, not exactly, Your Honor, because Ms. Brodbeck relied on the promise by one of the commissioners, which the chief executive has appointed pursuant to statutory authority, that the case was certified to have a public hearing. It was certified to the MCAD.
That public hearing was scheduled to occur after the limitations period expired.
Yes, but the certification to go to a public hearing was made before the statute of limitations had expired. At that point, Ms. Brodbeck made.
How does that change anything?
Because she was induced to make that decision by a promise of the agency,
but the limitations period still would have run by the time she got to that hearing.
Yes, by choice, Your Honor, but she was deprived.
She chose to file I think it was 2012. She chose the MCAD avenue, and there's very good reasons to do that, right?
Yes.
Decision in 2012 to proceed in this way, but for what happened with the appointment of the commissioner, that case would have proceeded along. The governor makes an appointment. MCAD says there's a conflict. I don't think you would disagree with me. There's a conflict. Dala's going to hear the case, and then Dala would have heard the case, and then they would have had their 30A appeal. You only raised the statute of limitations or the suit in the Superior Court because you're not happy that MCAD recused and sent it to Dala.
Well, Your Honor, that is illegal. The MCAD doesn't have the authority to send the case over to any other state agency.
So let's say I agree with you for the sake of this question. If a conflict arises, what is MCAD to do at that point?
It's an unresolvable conflict. Therefore, Ms. Brodbeck must be allowed to bring this in a court of law, because the statute obligates Ms. Brodbeck to start at the MCAD. It gives her the option to remove it. The MCAD. And
so the CMR regulation that your brother cites, I think it's 804 1.21, that says that MCAD can transfer to a qualified person. That doesn't apply here?
No, Your Honor, it doesn't say the MCAD can transfer to a qualified person. It says the MCAD can hire or choose to have the public hearing heard by anyone they deem qualified, as long as jurisdiction is retained within the MCAD. And there's very good reason for that. The first reason is that the MCAD, through 804 CMR 1 at SEEK, guarantees certain rights during a public hearing. One of those rights is that the MCAD had adopted by regulation 803 of the Federal Rules of Evidence to admit certain documents and records. That provision doesn't happen at DALA. It doesn't exist. Under 801 CMR 1 at SEEK, it doesn't exist. DALA also has very different procedures for a hearing. Matter of fact, a DALA hearing officer is allowed to mid-hearing to dismiss a claim for lack of jurisdiction. They can be done sua sponte, or it could be done by motion of one of the parties. Arguably, we could put forth a very compelling case, and then the government can stand up and say, Mr. Hearing Officer, you don't have jurisdiction to hear this case. You're DALA. This belongs to the MCAD. And they could have said, well, very well, then case dismissed. All you have left there is a 30A appeal, which I will get to in 30 seconds. At the MCAD, any aggrieved party by the decision of the hearing officer has the right by the CMRs to appeal to the full commission. The full commission is presumed by law to be the equivalent of experts in employment law and interpreting Chapter 151B. As a matter of fact, courts routinely hold that we give due deference. We give a lot of deference to MCAD's interpretation of Chapter 151B. Courts routinely hold that MCAD has the power to create policies for all employers to abide by. So the full commission review is very important. It's a very important step. It also holds precedential value both for the MCAD and for the Superior Court. Ms. Brodbeck was deprived of that without notice, without an opportunity to comment. The MCAD made up this rule as they went because they had an unresolvable conflict. The reason they had an unresolvable conflict is because of what the executive did. Commissioner Quinones then was the director of the EEO office within the DOC. She was a principal actor and a fact witness to what happened to Ms. Brodbeck. She wrote letters to her. She made decisions on behalf of the DOC. By the executive appointing her, they created this unresolvable conflict. The executive cannot have it both ways. The executive can't say, well, it wasn't the DOC who did it. It was just the executive, and therefore it should.
But you're not saying the governor appointed Ms. Quinones as a way to circumvent Ms. Brodbeck's claims.
Your Honor, I haven't asserted that claim.
Well, your brief reads that way.
Well, Your Honor, we weren't allowed to conduct any discovery at all because this was 12B6 out for purposes of the statute of limitations and equitable estoppel. But
Can I ask a quick question about the appendix in the case? I
Yes.
don't see the MCAD complaint in the record. Could you tell me where it is?
I can pull it up. I'm sure off the top of my head, Your Honor, but I don't know that we have included the MCAD complaint in the appendix. I apologize for that. So Your Honors, in sum, I know my time is about to run out. I would pray this court to reverse the trial court's ruling that the executive enjoys sovereign immunity for disability discrimination claims brought in the Superior Courts for violation of cognate federal law provisions because the legislature has waived such immunity for similar state law provisions. Further, I pray this court to rule that the statute of limitations should have been told by the trial court for handicap discrimination and retaliation claims arising under Chapter 151B, and that the executive should have been equitably stopped from asserting the statute of limitations defense because it was its own doing that created the unresolvable conflict. One last thing.
Thank you. We'll hear from the Commonwealth.
Thank you, Your Honor. May it please the court, my name is Matthew Birch. I'm an Assistant Attorney General representing the Department of Correction in this matter. There are two overarching points I would like to make in this argument. One is this is an appeal from a dismissal based upon Rule 12b1 and 12b6. So under the case law governing that rule, the verified complaint, which was quite detailed, had to raise allegations of fact that raised the plausibility that the plaintiff was entitled, the appellant, was entitled to a relief under the course of action she chose. The second is we respectfully submit that removing this case to Superior Court was not the appropriate manner to deal with the dispute that the employee in this case had with the MCAD's decision to exercise its rights to move this to the Division of Administrative Law and Appeals.
Can I stop you for a second? In your
Certainly.
brief, you cite 804 CMR 1.21 for the proposition that the MCAD could transfer to DALA as persons found to be qualified by the commission, but it might be what I have available for legal research right now, but 1.21 seems to be the section of the code that deals with the materials that the commission can use, and 1.02 I think supports your proposition that a hearing can be conducted by someone qualified by the commission. Do you know if that's correct, or am I wrong on that?
You made the same error I did preparing for the argument, Your Honor. The correct version that was in effect at the time of the events is actually on the addendum to the appellant's brief.
Okay, thank you.
There's been an amendment since then.
So the one that I'm reading is the new one. We're going to use what you've cited or what's contained at the end of the brief.
That's right, Your Honor.
Was what was in place at the time. Okay, thank you for
That's
clarifying
correct.
that.
It's addendum 72
Thank
on
you,
the blue brief.
Thank you. I'm sorry, that was confusing to me, so please continue.
It confused me as well, Your Honor. And if I may proceed, I think the first point I think I should address is the Americans with Disabilities Act argument. We've cited sufficient law from the Board of Trustees versus Garrett, which held that the states did not waive their sovereign immunity from suit under Title I under the ADA, down to the Supreme Judicial Court's decisions in Morris versus Mass Maritime, and also in Shedlock versus the Suffolk County Sheriff, which we quote for the proposition that the Commonwealth did not waive its sovereign immunity for Title I claims. With respect to the 3-year statute of limitations, again, this is a Rule 12b-6 motion, so we do accept as true all the facts that have been pled in the plaintiff's verified complaint, but they have to state a plausible claim. And I think everybody in this case agrees that the last adverse employment action that was pled occurred in August of 2014. The conflict of interest that the appellant cites in her case arose more than a month later on September 27, 2017. This complaint was filed more than 8 months after the last adverse employment action. So by virtue of the plain language of Chapter 151B and the facts that were pled, this claim is late. It's beyond the 3-year statute of limitations and was appropriately dismissed. We believe what the appellant would like to do here is to shoehorn what she's calling a fundamental fairness argument into this case through the equitable tolling doctrine. But as Your Honors pointed out, the equitable tolling doctrine would not apply here because the adverse event that caused this case to be tolled occurred after the expiration of the actual statute of limitations. But even so, the equitable tolling doctrine is applied very sparingly in employment cases. And when you add that case law, which we cite, to the fact that the equitable tolling doctrine is generally not applied against the equitable estoppel doctrine is not applied against the Commonwealth.
Well, I guess, let me ask you this. The adverse event occurred after the statute of limitation had already run, but that's because the plaintiff had accepted that it would have a public hearing on a date that was given by the MCAD, which happened to be, past the statute of limitations. So the act that caused it is the MCAD giving a date for a hearing well beyond the statute of limitations, which, if according to plaintiff, if everything would have gone the way anticipated, they would have a hearing in front of the MCAD. That was their option. But then there's a conflict. We can agree, say no fault of the DOC. There's a conflict, and MCAD has to get out of the case. But that doesn't change the fact that the reason for for that conflict to have occurred was the date that MCAD gave for hearing.
That's correct, Your Honor. And the question then becomes, does equitable tolling apply? Does equitable estoppel apply? Those are the doctrines that would apply to cure what would be an otherwise unfair situation in this case. And the equitable tolling doctrine doesn't apply because I note here the MCAD is not a party to this case. It's the DOC. The DOC is not alleged to have done anything affirmative or even by implication that would have caused the plaintiff not to have removed her case from the MCAD in a timely fashion. The second element under equitable tolling, the MCAD would have to have encouraged or cajoled her to do something, to not take her exercise her rights to remove the action in a timely fashion.
Why isn't offering a hearing? I mean, I'm not saying that DOC did this, but why isn't the fact that she was offered a hearing before the MCAD and she was accepting that, but that it gets put off for date beyond the statute of limitations, and then she's not then offered a hearing before the MCAD, but she's now has a hearing before another agency, which, as counsel suggested, might have different rules of evidentiary rules that are prejudicial to her, enough to say she was cajoled because she thought she was going to have a hearing before a body that would be able to present the case in a way that she wanted it presented.
I understand, Your Honor. There are a couple of points I'd like to make in response to Your Honor's questions. One is that the MCAD did have the authority to do what it did. Under 804 CMR 1.21, it was able to designate a hearing officer it deemed qualified. I think that's the language they use. It doesn't have to be somebody who's going to apply MCAD rules, someone they deem qualified. The other point is the MCAD under 804 CMR 1.01 reserved the right to make these rules flexible in the interest of justice in a particular case after giving notice to a party. What's interesting here, Your Honor, is when they gave notice.
Is deeming someone qualified the same as removing to a different jurisdiction?
I'm sorry, I can't hear your question, Your Honor.
Is deeming someone qualified to hear the case the same as removing the case to a different agency under a different jurisdiction?
If your question is naming someone you deem qualified the same as moving it to DALA? Yes. They could deem it a hearing officer. Why? Is that the question?
Yeah, that is. Okay. Because it's not as if you're saying what we're going to do is deem someone in DALA to be an MCAD agent officer, hearing officer for these purposes, right? We're actually saying we're going to remove this to a different agency with a different jurisdiction and different rules.
There are a couple of points there, Your Honor. Yes, it is appropriate to move to DALA. Number one, DALA, as the appellant admits in her submissions, is qualified to hear administrative appeals of all kinds. They're going to be hearing, in this case, an administrative record developed under Chapter 151B. There is nothing in the record that says they can't do that. Two, they're not challenging, in this case, the MCAD regulations. What they're challenging is their authority under the statute to do this in the first instance. The regulations are promulgated pursuant to that statutory authority. Three, DALA handles these kind of appeals all the time in a wide range of these appeals. Two that come to mind are they handle wage and hour appeals. And the other that comes to mind is that they handle the individual educational program assessments.
I get that they do that. That doesn't really answer my question. My question is, do they do it under the umbrella of DALA with the DALA rules and regs and how they follow hearings, or do they do it under the umbrella of MCAD and MCAD's way rules and evidentiary rules? Because if they don't, you're not getting a hearing under MCAD.
That I can't answer because it's not part of the record on appeal, so I don't know the answer to that question.
Okay, so you don't know the answer to that. And then my next question is, when you say, goes back to my very first question, when you say appoint someone qualified, is that, I don't see how that appoint someone qualified, the equivalent of removing to a different jurisdiction. For example, appoint someone qualified. Can you say, I'm appointing a Superior Court judge?
They could appoint a Superior Court judge in that capacity if Superior Court judge were able to do it without having any conflict with their current duties. I don't know if that's the case.
And would it then fall under an MCAD officer handling it, or would it be, no, this case is now removed to Superior Court?
I think there's been it would fall under the MCAD's regulation that allows them to appoint any person they deem qualified. I think the characterization earlier in the argument that they have to appoint someone who's going to apply the MCAD rules is not a correct characterization of 804 CMR 1.21 subsection 1. I think that might be causing some of the confusion. They can appoint somebody who they deem qualified. Now, if Your Honor is concerned about what are the consequences of this if the employee is not given the procedures that she otherwise would have had under MCAD, she does have her recourse through the Chapter 30A appeal. If there's a manifest.
So she has the recourse of spending more money on appeal because she wasn't afforded the same rules and regs that she would have had under if an MCAD, if it was done under the umbrella of an MCAD.
She would have to spend more money. She would have liked the decision Dala made, but
how is that, you know, how
with all due respect, Your Honor, fundamental fairness applies both ways. This case was teed up for a hearing. This is in the record. This case was teed up for a hearing for the MCAD before this conflict arose after the expiration of the statute of limitations. The Department of Correction and the people of the Commonwealth have a right to expect that the hearing would be heard in the manner that was chosen by the appellant in a timely fashion. What this does, if this fundamental fairness is granted in the appellant's favor under a doctrine that doesn't exist, if they're allowed to bring this case again in Superior Court, then we are the ones who are going to have to relitigate this case for years. We will have to do discovery again that was already done in the MCAD. We are the ones who have to wait for a trial judge to have a trial date available to try this case. So with all due respect, it does run both ways. And I think that the fundamental fairness—
Any cases where a conflict like this has arisen?
I'm sorry, I can't hear you, Your Honor.
Are you aware of any cases like this where a conflict has arisen, and what has MCAD done?
No, absolutely not. I think that's one of the problems. This was such a unique situation where a key witness was appointed by the governor to be a commissioner. The MCAD, this is not in the record, but the MCAD didn't know what to do.
So I have a slightly different question. Just out of curiosity, why did it take so long for this to progress to a hearing before the MCAD?
That I'm not aware of. I wasn't handling that matter. I think the answer to that, Your Honor, is there was discovery in MCAD. It was the normal course of the timeline for the MCAD to get it to a hearing. There was one in the record. There was allegation that the MCAD hearing was put off at the DOC's request, but that was a minor delay, as I understand it. So with that, Your Honor—
What were the options available then to MCAD when the conflict arose? Was the only option to send it to Dollar, or were there other options?
I'm not representing the MCAD. I'm speculating now. The other options would have been the parties could have waived the conflict, which I don't think would have happened here for very viable reasons. He was a key witness. They could have appointed another hearing officer from another avenue, somebody who may have been a past MCAD hearing officer, somebody who may have been a former Superior Court judge who's had 151B cases. They chose, under their authority, under their regulations, they happened to choose Dala. If the issue is Dala is unqualified to hear this case, I don't think there's anything in the record that would support that conclusion, quite frankly. So Dala, I think the Dala was the way that the case should have gone. It should have played out that way, and it could have played out.
I know you keep saying they appointed Dala, but they didn't appoint Dala. They sent it to Dala. I think there's a difference there. I think, I mean, it sounds like semantics, but there's a difference between sending a case something else or appointing.
Well, I understand what you're saying. I don't think it was ever sent there. I think what happened was it was removed right away to go to the Superior Court. They got the right to sue letter before anything actually happened, as I understand.
Right, I get that, but the action that they were taking was to send it to Dala as opposed to appointing Dala, an officer from Dala.
Yes, that was their decision. I see my time is up. If I may, I just want to point out that there is fundamental fairness in this case that favors the DOC, who has been litigating this case for years. This case began in 2012 when the first MCAD complaint was filed. Witnesses become stale, evidence becomes stale, and now what would happen if you allow a plaintiff, an employee, to decide to backtrack and move the case into federal court or Superior Court because they don't like what's happening in the forum administrative proceeding? It would have adverse impact on employment litigation throughout the Commonwealth. Thank you, Your Honors.
Thank you. You guys can both
Stream now.
All right. We now come to the final case on our hearing list this morning, case number 2019 P1647. This is a case involving termination of parental rights. The case is impounded. I will remind counsel, as always, this is an open courtroom, particularly so that we are live streaming to the appeals court's YouTube channel. Please avoid any reference to any names of the individuals involved. You can refer to them by mother, father, child, older sibling, younger sibling, and the like. And with that, I also understand that we are splitting time in a somewhat unusual fashion for this hearing. Each of the three of you has agreed to use 10 minutes of time, so that the total argument will be 30 minutes as always, but instead of having 15 minutes on each side of the V.
Correct.
Okay, who will be arguing first?
Attorney Kirchway?
Yes.
Okay, Attorney Kirchway, if you're going first, you may begin.
Okay, I'm getting a message that my internet connection is unstable and I don't see a clock.
The clock will begin as soon as you begin arguing. The steel will be replaced by a clock.
Okay, thank you. I represent the appellant mother. There's a saying, if something doesn't make sense, it's usually not true. And here's what doesn't make sense in this case. The idea that in September of 2017, we have a DCF assessment in which DCF is applauding mother's parenting skills. I mean, it's really very favorable if you review it. It's a great bond. The kids are happy and cheerful and mom is meeting their needs. And we also know that she was successfully taking care of child 2 from June of 2016 until the removal in April of 2018. So almost 2 years of successful parenting, and also taking care of child 1 from August of 2017 until the removal in April of 2018. And here's what doesn't make sense. Less than a year after that glowing parenting
We've lost the audio. We were frozen before.
Okay.
Okay, you're back.
Okay, so what didn't make sense is that less than a year later, DCF changed the goal to adoption and claimed that mother was unfit. And that just doesn't make sense because it's not true. And the evidence of mother's unfitness and to terminate parental rights is just not clear and convincing. Most of the findings that the judge used to justify the decree are erroneous, stale, or just don't indicate unfitness, as discussed in mother's brief. For example, the marijuana use, the homelessness, her past criminal record, her inconsistent mental health treatment, all of those things, I would ask you to really just set those aside, because none of those things in the past.
Counsel, if your client got custody of these children, where would she live with them?
Sorry, we're not getting your audio.
I don't hear anything.
No, I don't either.
I could call in.
Why don't you do that?
Should we take a break?
Yeah, let's take a break.
I will do that.
And then the session clerk will address what to do with your existing feed. So Brittany, are you going to close out the existing Zoom and have her the existing Zoom feed for Attorney Kirchway and have her dial in?
Yes, I can remove her existing from this meeting. And then the number that she should call should have been on the Zoom invitation.
Yes.
Okay, here we go. I believe this is her.
Oh, good.
Okay.
Hi, I seem to have been taken out visually as well as
Yes.
everything,
Oh,
but does that, should I
your image was frozen before in any event, so so let's just proceed with you on the telephone.
And
Okay,
what should
I apologize for the poor Vermont internet connection. That's how we are, I guess. Sorry. Anyway, so I will continue. The real concern here was father's criminal behavior toward mother.
Could I go back and ask you, the question I had asked you, this is Judge Blake, is if mother had received custody at the time of this trial, where would she have lived with the children?
Well, presumably she would have returned to a shelter where she had successfully parented the children in the past.
And was there any evidence at the trial that she could return to that shelter with 2 children, the ages that they are?
I don't recall if there was evidence about a specific shelter, but she had certainly been in various shelters with the children and never had a major problem getting into one.
And then what was her plan to address the younger child's special needs? What did she offer at trial as evidence about that?
Okay. I'm trying, if I can just hold on a moment, Your Honor. I don't recall exactly what was addressed to that extent, Your Honor.
Because when we're looking at current fitness, right, don't we also have to look at the children's needs? And I don't think anybody quibbles with the fact that that child number 2 certainly had some behavioral issues and some attachment issues that required intervention, was receiving IEP or early intervention services, and was mother in a position to be able to address those issues? And if so, what was the evidence at trial regarding that?
Your Honor, I do not believe that was addressed at trial. If I find out later, may I submit something to correct that?
I defer to the chief.
When would you submit something?
Oh, within a week.
And this would be just a record citation.
Yes, exactly.
That would be fine.
Thank you, Your Honor. So what I was trying to get at is that the real issue here was the domestic violence concerns, I believe. And we do know that the prior incidents, there were verbal altercations and threats, but no injuries. And those prior incidents did not preclude reunification. It was the one incident in April of 2018, which we know led to the final removal of the children. And mother did act protectively. She called the social worker, she filed a police report, she informed the shelter. She didn't, however, accept placement in a secure domestic violence shelter. And that was what.
Why isn't it fair for the judge to have said you had these earlier incidents that, as you say, were not violent, but they were verbally abusive, let's say. And then it escalates to something that's more violent. And rather than accept that this is a violent relationship where there's escalation here, she's unwilling to accept placement in a secure center to keep him away, unwilling to go to Pittsfield, which is, makes all these reasons as to why she can't go. The judge doesn't accept that they're valid. That's more like an excuse, and has these little incidents that show her continued willingness to be in a relationship, which harmful to her, but then also psychologically harmful to the children because he's a violent person.
Well, great question, Your Honor. And let's unpack what we know about this. We do know that father had a history of some gang leadership, but we also know that he was appropriate with the children at the parent-child visits. And we know that mom was a victim of his behavior and his threats. She had testified that nothing ever stopped him, and the social worker.
But isn't his, he could be loving to the children, but if he's violent to her in their presence, he is an emotional danger to them, and she was unwilling to protect against that if she's not willing to go to a secure place, if she's not willing to move to Springfield, if she's still willing to, show up at the same hotel that he's staying at, still willing to have a meeting outside where she knows that he works or lives in the area and is going to do, and coincidentally passes by. I mean, she's still willing to be in a relationship with someone, despite he may be good to them, that places them at a severe, serious, emotional damaging risk.
Well, Your Honor?
Yes?
So, can you hear me?
Yes.
Yes.
Okay, sorry. It's just hard to figure out what's going on. So, okay. Yes, but what we know is that back in 2017, when Mother she was doing all the things that she needed to do. And there is absolutely no evidence that Mother was ever instructed that she had to end her relationship with Father in order to keep her children. And there is no evidence that she was ever instructed that she had to go to a secure domestic violence shelter to prevent the removal of her children. So at the very least, based on her good parenting history, she deserved to be informed that these were the prerequisites for her to maintain custody. If she had been told...
Didn't Mom attend domestic violence?
She did attend domestic violence, and there's no evidence.
That be part of what she learned in her domestic violence training is you stay away from the abuser?
There's no evidence in the record as to what the content of the class involved, but I think that in fairness to Mother, who was the one who lived the experience with this man for so many years, she had made choices. And if DCF disagreed with a particular choice, they should have made it clear to her that if you don't go to a secure shelter, you will lose the kids. And I believe she would have done it if they had told her that that was the repercussion.
You can't see the timer, but you've got about 30 seconds left.
Oh, you're right. I cannot see it. Okay, so I'd like to touch briefly on the plans. The judge paid such poor attention to the evidence that she found that the girls were placed together for 4 months in finding 32. In fact, the social worker testified they were only together in a foster home for a day or two. That's at transcript page 266. The plans are completely insufficient. There's no evidence why child one's pre-adoptive home is suitable for her. There's no characteristics of the home to be sought for child two. And there's no findings that indicate that the judge considered how or why these plans are in the children's best interest, or even that they are in the children's best interest.
I will leave Judge Blake. Let me ask you though, because there was definitely evidence that the children couldn't be placed together because of some physicality between the two. So, and the judge recognized that, right?
The judge recognized that, yes, but we also know that the kids they got along fine when they were living together with Mom. So there was really no exploration as to what the possible causes of that could be, whether there could be any other family that could take both kids. It looks like my time is out, and but yeah, I'll leave the rest of the plan issue, and I ask that the court vacate and remand for further findings on the plan issue. Thank you.
Thank you. All right. Who is next, Mr. Peterson?
No, I believe it would be Attorney Dow, as
Okay.
I am the appellee entirely, so I am going to go last.
Okay. Ms. Dow.
Thank you, Your Honor. May it please the court, Attorney Deborah Dow, and I represent the children in this matter, who I will refer to, as I did in my brief, just for clarity, as child one, who's the oldest, and child two, who is the youngest. Just to touch on a few points made by Mother's Counsel, as far as Judge Blake's questions, you know, could Mother have parented these children successfully in a shelter? I think there's evidence, strong evidence, that Mother had not done that successfully in the past. And I think the evidence was ample in the sense that the judge went through those incidents. The trial judge went through those incidents dating back to the time that child one was essentially born. April 2015, first incident reported at the shelter between mother and father. That went on to August 2015. Father again reappeared at the shelter, causing violence to mother. November 2015, the child at that point in time, child A, was removed from mother's care due to multiple incidents, that mother being unable to successfully ensure the child's safety as well as her own safety in the shelter, and then refusing to go to another shelter where she could perhaps be more anonymous, and instead essentially in that case choosing the father over child one. So I think there is some indication that mother has not been able to successfully parent at a shelter in response to that question. In addition, I just wanted to state that as far as child two's special needs and whether there was any indication that mother could parent a child with special needs, I think there was evidence actually to the contrary. The judge specifically found that mother really struggled during these visits, that child two was on occasion had some temper tantrums. In addition to that, she seemed to have some emotional struggles as well during some of those visits. And mother really struggled, even in that 1 hour period of time that she had to can you hear me?
Yes.
Okay. To work with the child and to, ensure that she felt comfortable and that she was, receiving proper or adequate care even during that 1 hour period of time.
And at the time of trial, Attorney Dow, they were ruling out the question of autism with respect to child two, is that right?
Yes, and that
at least at the time of trial, there was not a formal diagnosis.
There was no diagnosis.
And that child was receiving early intervention, speech, and developmental services?
She had a multitude of services. And as I said, I think there was no indication that mother was necessarily aware of the services that she was receiving, in addition to what it would take to potentially parent a child who had special needs. And at least on an emotional level, we saw, or we were able to have some indication through the testimony that mother even struggled, not just with the, perhaps the learning issues, but with the emotional issues. So that said, the children do support termination, and they do support DCF's position with respect to that. Mother has struggled for a lengthy period of time with domestic violence. And I think that really is the crux of this case. And while the children were removed, there was a removal for mother, the child testing positive for barbiturates. This was child two I'm referring to, and THC at one point. The crux of this case really, from my perspective and the children's perspective, rests on the domestic violence and the untreated domestic violence. And I think we can see that even throughout this last removal, which then led to the termination. It certainly became clear that mother was not willing to re-engage in those services and was still continuing to have a relationship with father, to the point that there was sort of a surreptitious meeting during the time that she had visitation, and father was present outside. It was the first visit that they had outside, and yet somehow father seems to appear, and then the couple walk together off after the visit as a couple. So I think I think there's an indication that the parties were still together, mother and father were still together, and that certainly additional domestic violence training was warranted, as far as mother not being able to accurately, to pick up on those skills and to have an understanding, as Justice Maldonado indicated, as to, why this was still an issue, why going forward, that this was obviously problematic for the children. And it wasn't just an issue for mother, but as we know from Vaughn, custody of Vaughn, that ongoing domestic violence with a parent, obviously affects everybody in the household. And I think that's the case here. Children do support the position. However, that there certainly should have been more evidence or more indication and discussion as to why these children were separated on a permanent basis.
Yeah, let me ask you a procedural question though. You did not appeal from that aspect of the decree.
So I did actually file a late notice of appeal, which then was allowed, which then allowed me to at least try to do a hybrid brief. There was some information that as child's counsel I received on late information that led me to.
Is that in the assembly? I apologize, I didn't see that in the record.
Yeah, it's because it was filed late, it may not be. It was filed, Your Honor, I'd actually have to go back and look and maybe provide that just to make sure the court has it.
With the chief's permission, could I ask for a record cite on that through a 16L, Chief?
Yes.
Because I was concerned that it wasn't properly, your issue wasn't properly before us.
Okay. Yeah, it was. I can send that in if the court would allow that. If the court would.
I don't see it on the docket.
Okay.
I don't either.
It is in there, and it was filed. It was allowed, and DCF actually submitted a SIR reply brief with respect to that issue.
Okay.
So that said,
I see it. It's paper number 22 on the docket. That was in March of this year, March 17th.
Our docket, Chief?
Yes, our docket, paper number 22.
Okay.
Entered just as the pandemic was heating up.
Okay.
So in any event, the children strongly believe that there should have been more testimony, and Attorney Kirchway is correct that the record itself is wrong. The children have never been placed together in this current pre-adoptive home of child one.
So I read your brief, and please correct me if I'm wrong, that you thought there should be a remand as to the contact and the visitation between the two children, not as to the placement. Are you suggesting that the placement was an error? Or the contact was an error?
So my suggestion is to both, but my concern is to the fact that this wasn't an issue that trial counsel raised below. And so I'm not sure what the court would be willing to hear. However, I do think at a minimum, the court could hear the issue of the review as far as the contact. And I wouldn't raise these issues.
Any other visitation case where we say that the adoptive parents are in the best position to determine contact, and why wouldn't that also apply to sibling contact?
Well, I think that the case law has been clear as far as that is not in the discretion of the adoptive parents, and frankly, nor should it be.
The sibling contact.
The sibling contact, and nor should it be. These children, have suffered enough as far as separation, and we're looking at a lifelong separation for a potential one-time incident. And I think that in and of itself certainly warrants a review as far as, is this something that is actually a permanent issue? And if it's not a permanent issue, then I think the department has an obligation to show that the reason why this is ongoing or continuing in the fact that these two children cannot be placed together. I think there's very little evidence to suggest that these two children could not be placed together, and to ensure that if they aren't placed together, that contact is consistent and continuous in accordance with the court's order.
But what about the physicality from child number one to child number two? Isn't that of concern?
Your Honor, I think one incident, it could just be one incident. I mean, all we're seeing is, and you're talking about a lifelong separation for this one incident, and there's no evidence otherwise. Absolutely none. Not in the mother's visits, not in, you know, any other suggestion has been made that these two can't get along. So I would rest on that.
Okay, that will bring us to Mr. Peterson. Thank you, Ms. Dow.
May it please the court, I'm Jim Peterson and I represent the Department of Children and Families. As noted, the judge's primary reason for terminating mother's parental rights really was the domestic violence, a relationship with father that mother would not or could not get out of. It appeared to be unwilling, and of course, mother's instability. As far as
Mr. Peterson, I'm sorry to do this to you, but could we start perhaps with the second issue, which is the placement decision? As I read your reply brief, you suggest that child number one would have to be removed from her current pre-adoptive home where she's been in care for quite some time in order to place the siblings together. Am I reading that correctly?
That is how I believe so. However, I don't think I was as certain about whether that was an absolute necessity, because once the removal occurred, there was no testimony about would the foster parents of child one ever be willing to accept child two back in.
That was my question.
So the point I was making with that, though, however, goes to the children's issue that they should be placed together. There should be this presumption and that they need to be placed together. And if this is a situation where you have one child who has a pre-adoptive home that she is bonded with, she's bonded with well enough that she calls the foster mother, which led to a disciplinary issue with the biological mother in an inappropriate discipline in the parent-child visit. But she's got this relationship, the relationship with the two other children, this good home, they're meeting her needs. And if they can't take the second child, to agree with the children's position would mean you'd have to, as a practical matter, agree that if they have to be placed together, the child one should be taken from her otherwise satisfactory.
Isn't that an unfortunate situation created by the department?
In this, my understanding, and I will admit, as I had written in my brief, my belief was that both children were placed in the same foster home until the removal. And that is something I want to address. That is what I said. I'm trying to look at the transcripts right now to see exactly what both mother and children are stating that didn't happen. Children certainly are in a better position to know that, children's counsel, than I am. My understanding was that they were together at that point. At this point, they had placed the elder child with somebody. And my understanding was that they had tried to place the two of them together. But then it's unclear as well whether there was an incident or whether this was incidents. It's not clear in the findings. It's not clear in the testimony.
It's not even described, right? What the incidents were?
That the elder child was physically assaultive, I believe was the language, although you're right, it doesn't say exactly how, and attempting to push her down the stairs, which is more precise in that one. And again, it's not clear, was this one incident? It did not read to me as though it's one incident, but it's also not clear that it's one, that it's multiple. It's just not clear. Clearly something happened.
How much time did the siblings spend together before they were separated? I mean, part of the question as to whether they need to be together is whether they had actually bonded at all. So I can't remember the age difference between the two before they were removed.
It's about a year. It's roughly 13, 14 months, I believe,
right,
is the age difference. There was a period where the elder child had been removed, the younger child was back with mother, and they were not together. They were then placed back together with mother at some point. And after a couple of incidences that happened quickly and mother refusing to go to a domestic violence shelter, a secured shelter, they were removed. My understanding, which is apparently incorrect based on both Mother's Council and Children's Council, is that they were placed together in the same home at that point until the removal, the separation of the two children in late September. But there was, so they did have some time together. They also had some time apart. If my understanding is wrong, then they were certainly apart between April and they must have come together shortly before the end of September, because that's when the removal did happen. The separation rather happened between the two of them.
And putting now that the separation part aside, why do you say that the plan of we're going to look for an adoptive home without specifics is sufficient for a judge to rule on?
I disagree that it was without specifics, and that's why I think it's an issue. I believe, and the department's position, my argument is that there was sufficient information for the prospective placement to allow the judge to properly evaluate the department's position. And with respect to the younger child, who's in this case, there was both findings. Finding 34 is the one that goes to that child in particular, that she was special needs, that she was in early intervention, that she had speech and development services, that she had a lack of sleep issue. She struggled with taking turns, with sharing, with napping. And as mentioned before, at the time of trial, there was even an appointment with a specialist to rule out autism, which I think gives the scope of just potentially how more severe, because it's hard to tell just from early intervention what it is. Furthermore, right after that point, the adoption worker testified that she had specific homes that she had identified as potential placements at that point, and wanted to ensure that they are the right fit. And that follows immediately after this description of all of these things, the special needs that Serenity had, that the second child had. That only if that failed, if that didn't work, and that none of those people would be there, that then they would fall back to traditional recruitment methods at that point. And I would argue that that is sufficient, that there was enough there for the judge to have ruled. That's very different from the elder siblings facts, which again, those are laid out in finding of fact 30.
On this recruitment case where their child has special needs.
Pardon?
What is your strongest recruitment case where the child has special needs?
Oh, with special needs? I am trying to recall. I can't off the top of my head give you a cite to one. I can tell you though that just looking through Mother's briefs and some of her sites like adoption of Lars, there is a plan in Lars, adoption of Lars, that was approved, that this is acceptable to the court. And it was a very short plan: recruit a 1 or 2 parent family who are trained or have knowledge and special needs and are capable of dealing with children who have neurological and developmental delays, along with ADD and PTSD. That was sufficient.
Right, but that's more than what you have here, right? They're saying that's more than what seems to be on this record, because at least there, what that fit looks like is being delineated, whereas all you have here is this is her needs, and we just want to make sure it's a good fit, not delineating what that fit would look like.
It wasn't, well, and it would have been preferable, obviously, if this had been written and had been explained that way. I am arguing, my argument is that there is effectively the same. They didn't say 1 or 2 parent family, but in a case like that, is identifying a 1 or a 2 parent household really different than just saying a household? I mean, how many potential parents would there be in one? That they are trained or have knowledge and special needs. I'll admit that is not the specific language in here. But again, following immediately after that during the testimony, and as a judge, that's what the department wanted to ensure, that the identified and identified to the adoption worker, they weren't identified in the court, that those were the right fit. And I would suggest that is exactly that. But one other point.
And though, counsel, the judge did add that DCF was to look for a home that would encourage or promote, and not, these are my words, not the judges, facilitate the post-adoption sibling contact.
That's correct. And the judge did, which again, I argue in the brief, and I'm arguing here, that does indicate that there was a attention paid to these facts, that the judge is aware that there was some kind of bond, they do get along well, and that should not be terminated. One thing I do though want to get to, because I see my time is running out, is that I had suggested in my original brief that this can be simply remanded on those facts. However, in the surreply, as I note in there, every year there must be a permanency hearing pursuant to 11929B. I don't think it's going out of the record to note that it has been after a year. And I believe that you can even take judicial notice of the court's docket to see that it has happened. And I would suggest that a remand would simply be redundant. This is a concurrent, there's two tracks on this case. Once the termination happens and the appeal happens, that does not end what happens in the trial court. And children are still represented, all the parties are represented, things go forward, these permanency plans, hearings happen.
Well, mother doesn't get to attend those, right? Once her rights are terminated?
That's correct. This is for the children in this case. But they are represented. And again, I don't think I have to go outside of the record to say you can look at the juvenile court's docket to be able to at least determine that it has happened and they were represented during what happened, and probably also to see what the result was. But I would suggest—
Thank you for that, Mr. Peterson. I see that your time has expired.
Thank you, Your Honor.
Okay. That concludes